Hello and welcome back, or just welcome if you're new here. I'm Common Free, I'm an employment relations practitioner, and I'm also the owner and director of Free Employment Relations. I've included a list of my credentials in the description box below to give you some peace of mind around the content that I share. Relevant for today's video is that I have chaired close to 3,000 disciplinary hearings in my career in over 500 different companies. That means that I've got a lot of experience with disciplinary hearings, and I would like to share that with you. The disclaimer is my usual disclaimer. I share a lot of information in these videos, but I'm not able to cover every exception or every nuance. Therefore, these videos are for educational purposes only. Please contact a professional if you need assistance. Today's video is an overview and a lot of details about disciplinary hearings. I have other videos on my channel that refer to specific parts of the disciplinary hearing, and there are a lot more videos coming that refer to other specific parts of disciplinary hearings. So continue to check my channel as I update it and provide more information about disciplinary hearings and other employment relations information. It was clear to me from my YouTube analytics that people would really like more information about disciplinary hearings. So who is this video for? This video is for anybody who would like to chair a disciplinary hearing. That includes practitioners like me or people learning and studying to be an employment relations practitioner or work in the field of HR. But it also includes managers and leaders within companies who are tasked or want to be tasked with chairing disciplinary hearings. This video is also for employer and employee representatives, and of course it is for employees as well who may be asked to attend a disciplinary hearing, and you're watching this video because you would like to know what you can expect, what your rights are, what your entitlements are, what are some things that may feel very unpleasant to experience in a disciplinary hearing, but it is not necessarily unfair or non-compliant with the labor legislation. There are many queries that I get from employees regarding specific elements of their hearings that they would like to know whether that was fair or unfair in terms of the legislation. That and so much more will be covered in this and other videos pertaining to disciplinary hearings. Now, the final part of my introduction before I get into all of the information about disciplinary hearings. I do my best to put out a lot of free and affordable information to the parties of the employment relationship because I really like to enrich the experience of the parties to the employment relationship. If you find value in the information that I put out, please consider supporting me such that I can continue to put out information and improve on the quality of that information that I put out. Ways that you can support me to do that is to support any of my videos and my channel, liking, commenting, subscribing, sharing videos that you think are helpful with other people, as well as if you find value in it, purchasing my affordable templates that are linked down below. Another way that you can support me is to buy me a coffee, and that link is also down below. That all is very supportive, but I would also like to say I do appreciate you being here with me today, and I would love to continue to bring content that adds value. So please let me know in the comments what I can do to add more value. Thank you, and let's get going with the information about disciplinary hearings. A disciplinary hearing. The first thing that I want to say, and this might seem obvious, but it is not obvious, and it is something that I see a lot of people make a mistake with. A disciplinary hearing should be reserved for disciplinary issues only. In the employment relationship, a dismissal can take place for one of three reasons. The first reason is for conduct, that is misconduct, that is disciplinary issues. The second reason pertains to somebody's capacity. This is their ability to do their job. There are a few things that fall under this one, but the most common ones are poor work performance and medical incapacity. The final reason that somebody can be dismissed is for something that pertains to the business, and it's not about the individual employee's behavior. And that reason is operational requirements. This is commonly referred to as a retrenchment or a redundancy. Just to stress this point, these are the only three reasons that somebody can be dismissed for it to be fair. If it's not one of these three reasons, then that dismissal is not going to be fair. And when I say fair or unfair, I'm speaking specifically in terms of what the labor legislation requires. Now, of those three reasons, a disciplinary hearing is only conducted for disciplinary matters, which is conduct, commonly referred to as misconduct. That is to say that an employee broke a rule, doesn't have to be a written rule, or a standard in the business. Disciplinary hearings are not to be used for performance matters, and it's inappropriate to do so. While we want management to avoid scheduling a hearing for something that is not disciplinary, sometimes it isn't that clear, especially with senior management. There's a lot of gray area between what is considered a disciplinary matter and what is considered a performance issue. Now that's where it's the chairperson's role to pick up in the hearing itself if the hearing is being held for something that is not a disciplinary issue. And the chairperson then needs to stop the hearing and advise that the appropriate procedure be followed and not continue with the hearing. I do understand that performance matters are more difficult to deal with than misconduct. However, that's not a reason to use the incorrect procedure. If you would like to make performance issues much easier, I have a video linked down below on probation and poor work performance. I have a template that is widely used by many companies, and it helps leaders and managers to manage performance and deal with performance issues in the appropriate manner. So please, again, don't use the disciplinary hearing for performance issues. Reserve it for disciplinary issues, which is misconduct. The next thing is, should you have a disciplinary hearing in the first place? I have an entire video dedicated to this, so I'm not going to cover that in detail in this video. The important thing that you want to take note of is you do not need to have a disciplinary hearing in all cases, and it actually is not recommended to follow a formal procedure for all disciplinary matters. Therefore, disciplinary hearings should be reserved for cases that are very serious or cases that are very complex in nature. Now let's look at the order in which things take place. The first thing that happens is there is an incident that happens, or multiple incidences. The first thing that leaders and managers need to do is gather information about what happened. This information will inform whether you need to have a disciplinary hearing or not. It will also inform the charges that you're going to put on the disciplinary hearing notice. It's important that the company do due diligence to gather that information before the hearing takes place. We run into a lot of problems if a company did not gather all of the information and we start to have a hearing. It's a lot more difficult then once the hearing has started. There's a lot of parts to this, therefore sometimes the hearing needs to be postponed, or there have been cases where a company comes unprepared to a disciplinary hearing and insists on it to be completed. The sanction or the outcome is given, and then more information comes out later where the company would have wanted a different outcome or a different sanction based on this new information that's come to light. But then it's too late to do anything because you've already issued a sanction. It's a company's responsibility to ensure that they gather as much information as they can prior to the disciplinary hearing taking place, and only schedule that hearing once they feel comfortable that they've gathered all the relevant information or all the information that they can gather. In most cases, it is better to delay the disciplinary hearing to conduct a proper investigation than it is to rush into a disciplinary hearing where more information is needed. Now, once a company has decided they want to schedule a disciplinary hearing, the next thing that you do is you issue a notice to attend a disciplinary hearing. Please note that in this video and in a lot of my content, I'm going to use the word disciplinary hearing and disciplinary inquiry interchangeably. They mean the same thing. Regarding the notice to attend a disciplinary inquiry, I have my template that is linked down below. I also have an entire video that is dedicated to the notice to attend a disciplinary inquiry for employees and leaders to understand exactly what should be on that notice and how to issue the notice and explain the various parts to an employee, as well as my other tips around issuing a notice to attend a disciplinary hearing. When issuing the notice to attend the disciplinary hearing, the employer, and just remember when I say employer, I also mean anybody tasked with representing the employer, so that's any of the supervisors or managers. The employer needs to decide whether they are going to suspend the employee pending the disciplinary hearing or not. If an employer decides they would like to suspend the employee, I do have a suspension template, and that is linked down below. What I would like to remind you of is it is not good practice to suspend all employees pending disciplinary hearings. This should be an explicit decision that is made based on a few factors, but predominantly the trust in the employment relationship and the severity of the incident that occurred. And just a reminder that suspension pending a disciplinary hearing is a paid suspension. Therefore, my tip is also to contact your chairperson or arrange the specific date of the hearing prior to suspending an employee. Now back to the notice to attend a disciplinary hearing. There are two big things that you want to focus on here. The first one is on a notice to attend a disciplinary hearing, you need to state the charges. This is where I find probably most commonly people do struggle with this one to formulate the charges appropriately. I also see that there is a lot of errors that relate to charges. Because I know that this is something that many people struggle with, I do have a guide that is linked down below. In this guide, I have included the categories for offenses and their definitions and when you would use them, and things like when you would say something is gross negligence versus just negligence, and also examples of how to phrase different charges that fall into different categories. So again, that is linked down below to assist people. Please, very important, it is not appropriate to simply put gross misconduct on a charge sheet. Firstly, because there needs to be more information on a charge sheet, and we should appropriately categorize the offense, because the second thing is that putting misconduct on a charge sheet is redundant. As I explained at the beginning of the video, we only have disciplinary hearings for misconduct. Therefore, by definition, if you're having a disciplinary hearing, it's for misconduct, and we don't need to put that on the charge sheet. We need to put the category that is more appropriate to use, which actually and accurately describes the behavior of the person. Now, how a charge is formulated is you will put the category, which I just discussed with you. Then you will put the specific behavior and maybe some other details about the behavior. And at the end, this is optional, you can put the consequences or the potential consequences or the outcome or potential outcome. The most important thing for charges is the behavior and the details. If you need to leave off the categorization because you don't know which one is appropriate, or you want to leave off the potential or the actual outcomes, that's fine. Ideally, we want all three, but if you need to leave those off, leave it off. But you cannot leave off the behavior and the details of that behavior. Then the next important thing that you're going to decide when you're issuing the notice to attend a disciplinary hearing is who's going to chair the hearing. As a professional chairperson, as somebody who does this as my job, I'm telling you it is not necessary in all cases to have an external chairperson chair hearings. I make these videos because I believe that we can equip leaders internally to be able to deal with many of the disciplinary matters, and that outsourcing a disciplinary hearing should be reserved for particular severe or particularly complex cases. And then even if you do choose to get an external person, it is also important to decide whether it is sufficient to get a more junior chairperson or whether your case is such that it does require quite an experienced, skilled chairperson. So it's important to consider when you're deciding who's going to chair your hearing, whether it's internally or externally, and if you go externally, to what extent you want the person to be very experienced is, of course, do they possess the knowledge and the skills to chair a hearing? I believe that many people can possess the knowledge and skills to chair a hearing, and that is why I make these videos and I provide resources such that managers can equip themselves to chair hearings internally. Now, once you've established that somebody has the skills and knowledge to chair a disciplinary hearing, the second and very important part is what I would refer to as their emotional ability. Now, despite what many people might think, you do not want a chairperson who comes across as angry and scary as their main approach to disciplinary hearings. This creates an aggressive, hostile, defensive situation, which in my experience is not beneficial to your business. You need somebody who is able to remain calm and respectful at all times, while still being firm in the management of the procedure, such that the hearing is conducted effectively and efficiently. You need to have somebody who is able to deal with uncomfortable situations, and not just somebody who is aware of the legal requirements for chairing a hearing fairly. So essentially, you want somebody who has conflict management skills, negotiation skills, and somebody who is very good at prompting and steering the conversation and the dialogue in the hearing such that you're staying on track and you're getting the relevant information in that hearing that you need. In my experience of chairing disciplinary hearings, they can very easily become very derailed by lots of emotional dialogue, or they can become incredibly adversarial or defensive, such that the parties aren't really speaking about the incident that occurred. Most of what is happening is more of an emotional argument. You need a chairperson who can manage the procedure such that the parties still feel that they are respected, but you are getting what you actually need. And that is what happened and why did that happen? And if it happened, now what do we do about it? This is what we need the hearing to be about. What the emotional ability of a chairperson also offers you is that disciplinary hearings for most people is a very difficult experience. And the important thing is a chairperson needs to not make that worse for the person. A structured discussion is important. However, and I'm going to cover what the hearing structure looks like in this video, but you also need a chairperson to know when there is a requirement for flexibility and what they need to do on a case-by-case basis to ensure that the hearing is conducted effectively, rather than just march on with this specific checklist that they need to get through for the disciplinary hearing. A chairperson needs to know when you're on point or when the discussion has gone off point and bring it back to the point. And this is for employees. It isn't unfair if a chairperson cuts you off to bring you back to what is important to discuss. An experienced chairperson knows whether the information you are providing makes a tangible difference to the outcome or not. So some people in a hearing will think that certain information is very important to be said or to be heard. However, the chairperson will know, does this information actually make a difference to the hearing? You are not infringing on somebody's right to share their side of the story if you ensure that the conversation stays on point, or you bring them back when the dialogue has derailed on some tangent. Seldomly should an average hearing take more than 1 to 2 hours. Of course, complex matters with lots of witnesses can take much longer, but an average matter should not unnecessarily be drawn out. It is the responsibility of the chairperson to manage this. Yes, a manager needs to prepare as well to ensure that they have all the information ready to present in a fairly structured manner. And yes, we'd like employees to also prepare sufficiently before the time, bring all that information, have it in a structured manner. But the reality is that often doesn't happen. And it falls to the chairperson to ensure that the way that the hearing goes is a somewhat structured or at least stays on point, allowing for flexibility for specific cases. There's a lot more that I can say and a lot more that I will say on the softer skills of a chairperson and how this really makes a difference, and the way that chairpeople can cultivate this skill and managers and leaders can cultivate this skill to improve the way that they can chair a hearing. Because initially when people are learning to chair a hearing, you will see that they will pretty much stick to a specific structure. It might come across a little bit robotic, and the more you do it, the more comfortable you become with it, the more it will seem like it has a natural flow to it. But that being said, at the beginning of all this, I mentioned that you don't want a chairperson who is going to come across as angry or scary. And I understand that this is sometimes an appeal for people to get this chairperson because you think, okay, they're going to scare the employee into not doing X, Y, and Z again. However, we can and should correct behavior in a more effective way rather than just using the fear tactic. I've been chairing hearings for a very long time. As you heard, I've chaired many hearings. I've also done many appeal hearings, many reviews, and many CCMA cases. But it was only a few years into my career that I became well-versed and experienced in what is referred to as nonviolent communication by Marshall Rosenberg. Once I discovered what I will refer to as the art of nonviolent communication, the structure and the particular elements of my hearings did not change, but my mannerisms and the way that I spoke to people did change. Prior to that, I was trained and I was surrounded by many chair people who prided themselves on having a very stern, almost robotic approach and getting through a hearing as quickly as possible. Now you heard that I do think that efficiency and effectiveness in a hearing is very important. However, I put a greater emphasis on how the parties are treated in a disciplinary hearing. And I recognize that my body language, simply the way that I spoke to people at every part of the hearing. And again, you'll see this in my other videos when I speak you through things like how I do my introduction and how I make slight alterations depending on the person that I'm speaking to. So I started to incorporate this new skill, so to speak, into the way that I chaired hearings. And what I saw as a result of it is that the hearings probably took about 10, maybe 15 minutes longer. They didn't take much longer than before. And that was also because the way of speaking to someone, if it is compassionate and respectful, yet still firm, we stay on point and we get to the point and people aren't as defensive. So therefore they share that information a lot more freely and we're able to make a better decision in those hearings. But what I also saw from that was probably before the time, maybe around 10% or less of my cases would go for further adjudication, be that they would be appealed internally or they would be referred to the CCMA. After I started implementing nonviolent communication into the way that I did things, I saw less than 1% of my cases go for further adjudication. And it's actually close to 0 of my cases. Now, I just want to come in here and say that there is not a fear of further adjudication. There should never be a fear of further adjudication. We do not make decisions out of a fear that somebody is going to take it further. I'm simply sharing that based off of my experience, the way that we treat somebody in a hearing can prevent unnecessary spending on both sides of resources going for further adjudication. Where that decision was made, and it is, although somebody does not want that outcome and doesn't necessarily agree with the outcome, they know that they were treated fairly. They know that their rights were upheld and they were treated with respect. I understand this is more of the softer side of things, so I'll make other videos dedicated more to that, and I'll provide examples for how I deal with specific cases. For example, when people are crying or when they are shouting and enraged, or when someone just flat out refuses to speak in a disciplinary hearing, or when somebody is so defensive that we can't understand what they're saying, or they're speaking completely in emotional language that doesn't refer to any type of behavior. This is very common, by the way. I will make videos dedicated to how I handle those specific scenarios and give you some examples of wording that I use. But for right now, let's get back to the actual hearing. Now, the next thing, we're on the day of the hearing and an employee either refuses to show up or just doesn't show up. The chairperson needs to make an explicit decision about whether or not you are going to continue with the disciplinary hearing. I will make a video where you consider the different factors and what I do in different scenarios, but the important thing that I want to say here is it needs to be an explicit decision and not an arbitrary rule like, okay, if someone doesn't show up for the first time, then we postpone it, but if someone doesn't show up for the second time, then we don't postpone it and we have it in the person's absence. That is arbitrary. The chairperson needs to look at the facts on the day of the case and make a decision about whether they're going to proceed in the person's absence or whether it is a better idea to postpone the hearing. Like everything in the employment relationship, it is important to have standardization, it is important to have consistency, but it is also important to have a degree of flexibility that allows you to deal with the case that you have on hand. And you should be able to justify objectively if you deviate from how you consistently act. Consistency in the employment relationship is not treating everybody exactly the same. Consistency in the employment relationship is treating everybody the same if the factors are the same, but deviating from that when the factors differ. Now moving on, let's say the employee did arrive. The next thing that's going to happen is that the chairperson needs to introduce themselves and introduce the procedure. I have an entire video about this where I share my exact chairperson introduction and explanation of the procedure and the way that I phrase it and the ways that I alter my phrasing in specific scenarios. That is linked down below. Feel free to copy it and use it word for word or take some inspiration from it. Also linked down below is currently my most purchased template, and that is the chairperson form that I use every single time I chair a disciplinary hearing. This is the document that I use to take notes when I chair a disciplinary hearing. Usually I'm taking those notes electronically, but you can't print it out and write those notes out if you'd like to. This helps me to have consistent notes across different hearings that I chair. It also helps if you're not as experienced with chairing a hearing because it provides the structure on that form. So all of the relevant information that you want to capture is on that form, and the way that you complete it is typically also the steps to the disciplinary inquiry. This is quite a valuable tool. It also includes the procedural questions. So this is what happens after the chairperson has introduced themselves and explained the procedure, is there are a few things that a chairperson needs to establish before they can continue with the hearing. Now, if you cannot establish these things, you cannot proceed with the hearing. So they are very important to upholding the employee's rights and to ensure that you are conducting a fair disciplinary hearing, which is ultimately one of the primary jobs of a chairperson. I also made a video that is entirely dedicated to the procedural things that you need to establish before you chair a disciplinary hearing and the way that I phrase these questions and ask them to the employee. How you phrase this and how you go about these, again, is very important because it avoids unnecessary derailment and tangents and also unnecessary postponement of disciplinary hearings. Now, once that has been completed, the chairperson has introduced themselves, they've introduced the procedure, and they have established all the things that we need to establish for us to continue with the hearing. The next thing the chairperson is going to do is pick up the notice to attend the disciplinary inquiry and read out the charges one by one and ask the employee to plead guilty, meaning yes, they did it, or not guilty, meaning no, they did not do it. I like to remind employees that I'm going to give them a full opportunity to explain. Just for practical reasons, I need to understand at this point whether they agree that they did it or they disagree. What this information informs is what we're going to do next. So who is going to start speaking in the hearing? It's important for me to say, just because an employee pleads guilty doesn't mean we stop the hearing and say, okay, you're guilty now we decide on the sanction. No. If an employee pleads guilty, the only thing that's going to happen is we're going to start with the employee's side of what happened. And it makes the most sense that the employee then goes first, explains in their words what happened, and then the company or the company's representative can fill in any additional information or provide any more information that is necessary once we've heard the employee's version. But we still listen to the employee's version. This is very important because, and no, this does definitely not happen very often, but it has happened more than once in my career where an employee pleaded guilty. I listened to the facts of the case and I found that they were actually not guilty. So it's important to still listen to the facts of the case. Now, if an employee pleads not guilty, saying they don't agree, they didn't do it, and remember, this is not guilty or guilty to all of the charges. If they plead not guilty to some of them, but guilty to some of them, then chairperson needs to decide just practically, where are we going to start with the hearing? And I usually base that based off of the ones that they pleaded guilty to or not guilty to. But as a general rule, if they plead not guilty to one or more of the charges, we're going to start with the company's version of what happened. Then the company will explain what happened. If there's more than one charge, then you can take it charge by charge. That just usually structures the conversation in a better way. And once the company has completed that, the chairperson again can decide, do you want the company to cover all of the charges and then the employee asks questions? Or do you want to take it as a charge by charge? So you do one charge, then the employee asks questions, and you go to the next charge, employee asks questions. Based off of how the things are going, based off the types of charges, the chairperson can decide what is going to work best here. The other thing a chairperson can also decide is, do you want the company to call their witnesses at that point in time, or do you want them to present their evidence at that point in time? Now, typically somebody would. So you would have the company share their side of the story, then the employee will ask questions, and then the company might bring any of their witnesses or show you any of their footage in the form of photographs or video footage or sound recordings, etc. Now, while this is the most typical structure for a disciplinary hearing to go, based off of what is being presented, it might be more effective and more efficient for a chairperson to say, okay, well, the company explains their side of the story first, then you have the employee ask questions, then the employee states their side and the company can ask them questions. Then you decide between the parties whether it is still relevant and necessary to call in the witnesses or to look through the evidence. Because a lot of the time, if something's not going to be disputed, then it's unnecessary to call in that witness or to look through, say, 15 minutes of video footage where the employee isn't even disputing what that video footage is going to show. But essentially, the important thing is the company is going to get their time to share their side of the story. The employee is going to get an opportunity to ask any questions. The employee is going to get an opportunity to share their side of the story, and the company is going to have an opportunity to ask them any questions. Both parties will have the opportunity to present any witnesses that are relevant to the case. I have denied witnesses where the information the person is going to provide is not relevant and is not going to make a material difference to the outcome of the disciplinary hearing. And then also to present any information that they would like to present, again, that's going to make a material difference to the hearing. Obviously, it's important for me to say, to deny a witness is a very rare thing. And of course, I didn't just outright deny it. I do ensure that the employee agrees and understands why the information that person is going to provide is not going to make a difference to the outcome of the disciplinary hearing. Now, the important thing for a chairperson throughout all of this, and I've mentioned this several times, but we're going to go to a next part of that, is to structure the conversation. Now, a chairperson will know, or should know, simply by looking at the charge sheet, what we need this hearing to be about and what information the chairperson needs to make a decision. This is how you keep it on track, is based off of the charges. You know, what information do I need to make a decision of guilty or not guilty on this particular charge? So I'll give an example. If the charge is insubordination, in that the employee did whatever they did and the potential consequences were whatever those consequences were. Immediately by seeing that insubordination is on the charge sheet, we know we need to look at, was there some kind of instruction or directive that was given by somebody in a leadership position? First of all, establish that. Was that instruction or what was given through to the employee or the request to do something, was that legal? Was that reasonable? Could the person do what they were asked to do? Was it also direct and clear? And then we need to understand, okay, yes, once there was this instruction given, did the person refuse to comply with this instruction? Did the person refuse to follow leadership's instruction, where the instruction was legal and reasonable and direct? Now we know insubordination is a defiance of the leadership structure. It's a breakdown of this leadership structure. Therefore, chairperson knows we need to look for information that pertains to that. Let me give probably a slightly easier example than insubordination, slightly easier charge. And that is a very common one, which is unauthorized absenteeism. It's usually phrased as unauthorized absenteeism on whatever the date was the person was absent. You usually add something like without permission or without authorized leave or so forth. In this hearing, you're going to establish, firstly, was the person absent or were they not absent? Okay, only once we've established, yes, they were absent, do we move to the next point, which is, did they have a valid reason for being absent? For example, so did they have any authorized leave? Did anybody give them permission to be absent? Or if they didn't have explicit permission to be absent, was their absenteeism something that is deemed valid in terms of the labor legislation? So the charges mean that a chairperson already knows what information they need to gather. So one of the tips that I give to people who are learning how to chair disciplinary hearings and who are in the process of improving the way that they chair disciplinary hearings is, again, you can use my guide down below for all the categorizations of offenses. It's in there with detailed descriptions of each one of those. And this I found very helpful for many people who I have assisted in training to be employment relations practitioners or to chair hearings, is that you have this list of categorizations and also their definitions so that when you know you're chairing a hearing, as a chairperson, you can request to see the notice to attend before the time. And often I do request to see it before the time, not so much about what the hearing is about anymore, because I feel very comfortable that I can share a hearing about anything. And that I'm sharing as reassurance that if it doesn't feel like that right now, lots of practice and you will get there. But I do that to check, because sometimes there's stuff on a hearing that is going to be a bit of a red flag for me that I would like the company to clarify, because I suspect that we might need to postpone on the day because that information wasn't given correctly, etc. But nonetheless, the point is a chairperson can ask for the notice to attend before you go and you chair that hearing. And you can specifically ask to see the charges. Now, if you have those charges, then you can write down for yourself, okay, the charge is unauthorized absenteeism. What are the things that I need to establish to be able to make a decision of guilty or not guilty based off of that being the charges? You can then take that with you when you go chair the hearing and have it as notes on your notes and to ensure that you keep the hearing structured and to the point of that information. I have, because I assisted the training of many employment relations practitioners, I have witnessed many junior people chair a hearing. And one of the things they really struggle with is when there's a lot of speaking, a lot of dialogue, and it's hard to keep track of everything. And it's hard to think, okay, but how does that play into the decision I need to make, etc., etc. So this really helps to guide the dialogue. And also for a chairperson, your brain literally starts to listen out for the information that is important for you to make a decision on, and which information does not make a tangible difference to that decision. This video is already very long with me wanting to share a lot of my experience in the hopes that it's going to add value. So another thing that I would like to share here is that when you are starting out and there is a lot of dialogue to work through and your brain has to really work on managing the process as well as being respectful to everybody, as well as gathering the right information and so forth, it's quite a lot to do. Now, I remember when I started to chair hearings, I would chair, I think, about 3 or 4 on a day. That was just the structure of the company I worked for at that time, is to chair a lot of hearings. And I would remember being very, very tired. My brain was very tired after a disciplinary hearing. Now, the more you do them and the more familiar you become with different charges, that's why I said that tip about the charges is very, very important. Your brain will automatically start to be able to almost filter out information that is not important. And it doesn't use as much, I'm talking about a brain like a computer, but processing power in a hearing as it previously did. And a lot of it becomes habitual and automated for you to do rather than explicit thought. And you can reserve explicit thought for the things that actually make a difference and actually matter to focus and hone in on. So I remember explicitly, there was a day a couple of months into me being a chairperson, so this is me saying it doesn't take that long depending on how many of them you're doing, is that I chaired 12 hearings in a row without a break. And I remember at the end of that, yes, I was physically tired, but my brain was fine and my brain wasn't as tired as I used to be chairing even 2 to 3 hearings in a given day. Okay, now we're back to the hearing. One of the things that I wanted to say when I spoke about unauthorized absenteeism is just a reminder, when you are drafting the notice to attend, please do not stack charges. Charge stacking is where you have multiple charges that all refer to more or less the same thing. Now, you can have multiple charges that refer to different things, but you cannot have multiple charges referring to the same thing. So with unauthorized absenteeism, we usually do have a second charge there. That's something like not following company procedures in that you did not inform management of your absence. That is not charge stacking because one of them relates to the actual absenteeism and the other one relates to the policy of informing management. But charge stacking is stuff like disrespect to your manager in that you did not inform them that you were not coming to work, or negligence in that you did not come to work. Things like that, they just they add no value because they're just repetition and usually incorrect repetition of the other charges. Sometimes people do this in an attempt to make a scenario look as severe as they experience it to be. However, it's important to note it does not do what people think it does. It actually impacts negatively the validity of your disciplinary process. So please don't charge stack. 1 charge per element of the incident that occurred. Next up, we're leading to the part where the chairperson now needs to make a decision of guilty or not guilty. One of the things I often say is that things should not come as a surprise to people in the employment relationship. And it's no different with the hearings that I chair. The way that I conduct the hearing, by the time we get to the finding, it is unlikely that my finding is going to come as any kind of shock or surprise to the person. And the reason for that is while we're going through the hearing itself, the way that I ask the questions, the way that I respond to the person in terms of the interpretation of the information that I've received, I share that with them as I go along, which means that by the end, when I'm making a decision, people don't necessarily need to agree with me, but they can clearly see based off of the information that was presented to me and me explaining to them how that information is relevant, how that information is perceived and received, then the finding I make does not come as a shock to them. So while they may not agree with it, they typically do agree that based off of the information presented to me, this is the reasonable conclusion that somebody would come to. This again brings me back to the way that you chair a hearing can reduce unnecessary expenses for both people spent on further adjudication simply by an extra sentence here or there in the way that you're chairing it, where it might be something like you're seeing some video footage and then you can say, well, what I'm seeing here in front of me leads me to think that this is the most likely conclusion here. Can you offer any information for me to think or interpret this otherwise? I ask questions like that. I obviously use different language depending on the scenario, such that the person can clearly see what information I am receiving and how that information is being interpreted and how that information would be interpreted by any reasonable person. So it's not about my particular personal opinion of any of this. It's simply about the objective information that is presented to me. So when I've received all of the information, we've listened to all of the witnesses, we have seen all of the evidence pieces, it comes down to making that actual decision. Before I make the decision, I always explain to somebody how that decision is made, even if they're a seasoned disciplinary hearing attendee. I will still say something like, I'm now going to make a decision of guilty or not guilty based on a balance of probabilities. Now, most people don't understand just what that refers to, and a lot of chair people might just say that part. In my experience, I found it's helpful to add at least one other sentence to say something like, the balance of probabilities means that I am going to weigh up the information that was presented to me, and literally, based on which one is more likely, I'm going to go towards that one. I explain to them that it's really just which one is more than 50%, rather than like in a court of law where you might require a beyond reasonable doubt, as in 100% sure somebody did something. Again, this information may not seem that important to a chairperson who's done many hearings, and this language use and these words are second nature to them. This is part of what they do. I do find that they make a difference to the experience of the person in the hearing, because I've received queries from employees, and I've seen it when I do CCMA cases where I read appeals and reviews, that people hear these words and they don't necessarily always understand them. Or it's something like, someone believes that you made an entire judgment of them, where if somebody understands your job as a chairperson is to take the information that is presented to you, and then based on that, you have to come to a decision. You can't have an indecision. So even if it is 55% the one way, I need to make that decision. I explain that to somebody such that they don't take it as some kind of personal judgment. They really see objectively this information presented here. How that makes a difference is when considering whether the decision was unfair or not, they need to decide, did somebody apply their reasonable mind to this appropriately? And based off of that, come to a decision. And should this information have been presented to somebody else, would they have made a different decision? Rather than it being about whether they are wrong or right or some kind of moral judgment, those things often come into play in hearings. We want to separate from that. It's not a moral judgment. It's simply a judgment of whether this behavior took place, yes or no. Right, so if the finding is one of not guilty, then I simply explain. I weighed up all the information presented to me of the charge of, and then I read out the charge. I find that you are not guilty. I then will explain that the company will issue the paperwork. This is the end of the case, and that's where it will stop. However, if I find that somebody is guilty, I will go through the charges one by one, and for each one of them, I will give at least one sentence as to why I found the person guilty of that particular charge. I won't simply say, oh, based off of the information presented to me, I find that you are guilty to the charge of. I will say, based off of the information presented to me, I found that it is likely that this, and this transpired, or sometimes, it's most definitely that this, and this transpired. And therefore, I find that you are guilty to the charge of, and then I will state the charge. And I will do this for every charge on the charge sheet as a separate finding. It won't be a guilty as a whole. It will be to each particular charge. If a chairperson through the hearing has become aware that there may have been an error on the notice to attend, or that the categorization of the offense, because sometimes it's not clear what it should be categorized at. However, that is a very small minority of cases. So usually it's more that people don't really know from a skills and knowledge perspective where to categorize it, but there are times where you will actually need to go through the hearing in order to understand which category it is. In those cases, people might put on the notice to attend. They usually put something like dishonest conduct or gross negligence in that something happened. So if there's an error, or the chairperson picks up that the categorization or there was some kind of error with the charge, or there was an or scenario, then the chairperson, before they make a finding, needs to establish what the charge will be such that they make a finding on the final charge. It is permissible and it is fair to make changes to the charges in the hearing to ensure that when you make a finding, the charges accurately represent what actually happened. I can detail exactly how to do that in another video, but this is just to say that you can and should, as a chairperson, ensure that the charges are correct before you make a finding. Now, oftentimes these are minor changes, so it's small things like the date on which somebody was absent is stated slightly incorrectly. So often they'd be absent on 6 different non-consecutive days and one of those dates was incorrect, or there's just a sort of minor adjustment to it. But sometimes there are major adjustments to the charges and you need to handle that appropriately before making a finding. Right, now if somebody has been found guilty to one or more of the charges, we move on to the second part of the hearing. Now, so the first part of the hearing has been completed, whether the person did or did not do what they're being accused of doing. Now we move on to the part where the chairperson needs to gather information to make a decision and a recommendation for what the best outcome or sanction is given this guilty finding. And I typically explain it to an employee. So I'll explain, given that you were found guilty to one or more of the charges, we're now going to move on to what is known as mitigating and aggravating circumstances. Those are words that are not commonly understood by everybody. So therefore, I'll add another sentence to explain that these are the things that have an impact on what the sanction is going to be, given what transpires. So I also explain possible sanctions that a chairperson can put forward and explain to the person that I'm going to take them through various factors, and I'll also give them an opportunity to say anything that they would like to say that they believe can have an impact on the sanction. One of the things that I started to include in this part, based off of my experience of chairing hearings and finding that it really makes a difference, is that when something is very serious, I explain that to somebody before I even start the mitigating and aggravating circumstances. So I will say something to them like, you were found guilty of, let's say it was dishonest conduct. This is a dismissible offense. And I will explain that dismissible means that you are not automatically dismissed because it happened, but that is usually the outcome unless there is something that is strong enough to deter us from that outcome. Or explain to them if it's not a dismissible offense, but it is very serious, or there's been a lot of repetition with his particular offense. I try to let somebody know ahead of time that just objectively, this offense and being found guilty of this offense is very serious. And I find that helps to set the tone for what's to come, because sometimes people don't realize, and truly people don't realize, how severe the thing is that they've done and how severely it impacts on the employment relationship. So I find that how they approach the mitigating circumstances differs when there is an understanding of the severity. I only do this if I believe that it is necessary to convey that information. If I don't think that a dismissal is even a likely outcome for this hearing, it might be because at that point I haven't seen the person's record necessarily. I don't go into that information if I don't think that is necessary. So I'm just adding that if it's very obvious that this is a dismissible offense or that dismissal is a likely outcome, then I do explain that prior to us discussing any of the mitigating or aggravating circumstances. Now we'll move to the mitigating and aggravating circumstances, and we'll go through various factors. Again, these factors are written on my form, and I can also make an entire video dedicated to just mitigating and aggravating circumstances, take you through how I evaluate all of these different factors in the context of a different hearing. Just for now, I'm going to go through a few of them and provide a little bit of information, but remember, my template to my form is down below. Right, so as we're going through these mitigating and aggravating circumstances, you've already come to know that the way that I chair a hearing is I take the person along with me. It is important that something does not come as a surprise. If you do not feel like you are experienced just yet to do that, completely understandable. This is something I do because I've chaired so many hearings in my career. I'm able to do it, but it's something I do think that we should aspire to as a chairperson to do, is to take the person along with us. So I'm mentioning it for that, is to whatever degree you feel comfortable and it is appropriate, please take the person along with you so that nothing is a surprise. So because I do that, that's exactly what I do through mitigating and aggravating circumstances. We'll go through the typical ones. So it's things like, what is your job title? So the person will share typically what they do. And immediately, based off of that, I can share with the person, right, I mean, if it's relevant, some job titles don't make much of a difference to any kind of offense. But for example, if somebody is in a senior management role, I will automatically say to them, this will count as an aggravating circumstance because you are in a senior role. There is an expectation that there is a higher level of responsibility placed on you, and therefore offenses that you commit are considered more serious than somebody who is more junior. So it will be the same if, for example, someone is a driver of a vehicle, which again, there's a lot of responsibility put to that person versus, for example, the cleaner in an office building. So with the job title, I will explain to them whether it counts as a mitigating, meaning less, or aggravating, meaning harsher towards the sanction. So I'll go through the factors one at a time. A very important one here, and the hope is that managers are well prepared for this one and do keep accurate, neat records, but that's not always the case. And a chairperson needs to look at the employee's disciplinary record. It's very important to look at that file properly and not miss a warning that has fallen behind some other kind of paperwork, because that makes a big difference. So That part, depending on how big the file is, can sometimes take quite long, but a chairperson needs to only take into consideration which is relevant. So say, for example, the person has like 6 warnings that expired. I will just make a note. There are 6 warnings that are less severe that have expired. Now, I only make that note to indicate that the person has a record, not necessarily writing out the details of any of them. However, if 5 of those 6 are for the same thing that I'm doing that hearing for, I might make a note of that. But you do not have to detail every single warning on the person's file. It's more important that you detail the ones that are still valid and that you just make a note of the ones that are no longer valid, just in terms of a view of the person's general employment. Once we've gone through that, the employee will get an opportunity to say anything that they would like to say. I usually request that they say this straight to the company because usually the person representing the company is their manager. That is often the case with disciplinary hearings, and the relationship is between the employee and that manager and the company. So I ask them if they would like to say it straight to that person rather than saying it to me, as long as I can hear it. And I do find that people are typically more heartfelt in the things that they say when they're saying it to the person it matters most to. That also usually elicits some kind of response from the manager when they get their time to say any mitigating or aggravating circumstances. I find that it's important because we need to remember that an employment relationship is between people. So we mustn't forget the element of people in that process. So as long as I'm hearing this information, I think it's valuable that the dialogue be between the people the relationship is between. Now, once I've gathered all the mitigating and aggravating circumstances and both parties have had their opportunity to say something, there are hearings where there are more parties involved. So somebody might have an internal HR or even an internal employment relations person. We might also give them an opportunity to say anything that might have an impact on the sanction. So they'll speak about how this has been applied in the business before or any other information that they think a chairperson needs to know. Now, once I have all that information, I will ask the employee to leave the room so that I can give my recommendation through to the company. And I always explain to them that is why I'm asking them to leave the room, is as an external chairperson, I don't work for the company. That means I don't get to make the final decision. I get to make a recommendation that a company decides whether they are going to go with or not go with. Now, in most cases, that recommendation and the final decision do align, but nonetheless, it is an important step. And I do explain that to an employee because it does feel very vulnerable to be sent out as the only person who is now not a party to this information. So I'll give my recommendation through to the company and they will decide whether or not I can go ahead and give the outcome verbally. I do express to companies that it is my preference, if and when possible, to give the sanction to the employee myself on that particular day. It is very seldomly, but of course it does happen, where I don't feel comfortable to give the sanction on that day, and either I need more time to consider it before I'm going to give my recommendation through to the company, or there is a difference in terms of what my recommendation is versus what they would like to implement. In times like that, then I'm unlikely to give the outcome on that particular day, and I will go away and I will send it through to the company. So I'm not going to necessarily, unless I'm specifically requested, to come back and give the outcome verbally. In the case where I'm not giving it on the same day that I'm there, I'm really unlikely to come back and to give it. So in that case, someone will just receive it verbally through their manager or through somebody in the company and then in writing. But in the scenario where I am comfortable and the company is comfortable for me to go ahead, I do prefer to give the outcome verbally. Now, some people are not comfortable with that and they feel that it's best to go away and not to give the sanction on the same day. And sometimes you do need to do that. Sometimes you do need to go away and you need to think about it. I'm not talking about those circumstances. In most hearing cases, I do feel comfortable to give the sanction right then and there. And that is always my preference, because I do find that a lot of people would want the things to get to be done and to be concluded and to no longer being in a state of limbo and uncertainty as to whether or not they're going to continue to be employed. Now, the biggest fear that people have here is that an employee might not think that the chairperson applied their mind. And this again comes down to how you chaired the hearing. The way that I chair a hearing, I believe, makes it very evident that I did apply my mind. Because again, as I go through it, I explain to somebody how things are interpreted, how I interpret them, and they can see that any reasonable person with that information in front of them would come to that same conclusion. It's the same with when I give a sanction. I fully explain why I give that sanction. So before I say the outcome of this hearing is, I will say, these were the mitigating and aggravating circumstances presented to me, and I'll name 1 or 2 or 3 of them that had a really big impact on what that sanction is going to be. In particular, I will refer to the things that we mostly look at in the employment relationship. And that is the 2 things. The first one is, can we implement a sanction that is going to prevent this behavior from ever happening again? Can we implement a sanction that is corrective measures? And if the answer is yes, then obviously we're going to lean towards that. But I often explain to people there's a second element. And that second element is there trust in the employment relationship? Because an employment relationship can only continue with trust. Now, the reason why that part is very important is if the hearing is something like dishonest conduct, I can explain to somebody, yes, we could implement corrective measures in the sense that you may probably never do this thing again. However, dishonest conduct usually severs the trust relationship, and the company will feel the need to micromanage and observe everything that you do. And that is not the kind of relationship that should continue. So therefore, I explained to them, those are the 2 main things. And how did the factors in the hearing impact on those 2 things? And now based off of that, I give through what the particular sanction is, and then I explain what that sanction is. Now, this all sounds like a lot, but it's really not. It's usually 1, maybe 2 sentences, and the more you've done it, the more efficient you are at explaining it. Because I'm doing a video and it's not an actual hearing, I have to use a lot longer sentences than I would in a hearing where I'm just simply saying, okay, this impacted on this, therefore the outcome is this. So once I've given through the outcome, usually if I'm chairing a hearing, the outcome is either going to be a dismissal or a final written warning. Of course, there are exceptions to that, but those are the most common sanctions that I give. When I give that, I explain what that means. So with a dismissal, I explain that your last working day will be on. Please return everything that belongs to the company by this particular date. Your final money, along with any leave owed to you, etc., will be paid out on this particular day. I usually establish that stuff with the company when I've given my recommendation through to them, such that I can give that information to the employee. I do explain to them that they can claim UIF until they find a new job. If the sanction was one of a final written warning, I explain to them what is likely to happen should they commit the same or similar offense in the time frame that that warning is valid. And I make it very clear to them that this is really a final opportunity not to do the same or similar thing again. I don't give the paperwork right then and there, so I won't actually give the dismissal letter or the final written warning letter unless the company has that lying there or can print it out really quickly and they want to do that. But usually I'll go away and just say, the paperwork will follow. I'm just giving it through verbally now, and then the paperwork is literally just going to confirm that I said so verbally. So what a person signs is not an agreement with my outcome. It's simply an acknowledgement that this is the outcome that was given to them. So I'll typically send that to a company once I get home from the day or after the hearing, depending on if I'm sharing it online. Then the final thing that I discuss with an employee is their right to refer the matter for further adjudication. If a company has an internal appeal policy or a procedure that allows for some kind of internal review or appeal, I will inform the employee of this. If there is some kind of timeline attached to it, I will inform the employee of this too. So I'll say within the next 3 or 5 days, if you'd like to lodge an internal appeal, this is how you can do it. And if they don't have that, I just add the part of they can take it for further adjudication to the CCMA or to the bargaining council. If I know which one of those has jurisdiction, then I will just say you can take it to the CCMA or you can take it to the name of the bargaining council. But specifically, I say something in the lines of, if you found this procedure or the outcome to be unfair, you can take this matter to the CCMA for further adjudication. And then I tell them how many days they have to do it. So in the case of a dismissal, they have 30 days. In the case of any other sanction, they have 90 days from today. So from me giving that information. Now, the reason why I add the part of if you believe that the procedure or the sanction today was unfair, and I kind of really sometimes overemphasize saying that, again, because I don't like to waste resources. Not afraid of something being adjudicated. By all means, if something needs to go further, let it go further. In often cases, it's very important for things to go further. But I've had cases, and I'm not making this up, where I'm at the CCMA, and by the way, it's not cases of hearings that I chaired. However, this can so easily happen to any chairperson. This is why I'm sharing my experience, because I think this experience helps other chair people to be mindful of how things can go. But I have been at the CCMA more than once where a commissioner will ask somebody, oh, why did you refer the matter? And the person will say, because the chairperson told me to. And we'll all be a little bit confused. And then we'll ask like a bit more about, why did this chairperson say that? And often what somebody interprets as someone simply informing them of their right to take it further, should they believe that it's unfair and they have that space to take it to, and, they have that platform and so forth, they will interpret that to be an instruction that this is something that they are just supposed to do. And again, happen on more than one occasion. Now, we can't always control how somebody takes it, but just to be mindful of the language we use and the possibility of how that will be interpreted and whether that wastes somebody's time and resources. And I say that for both parties. It's not just about the employer. I don't think that an employee wants to unnecessarily spend their time, not necessarily money because the CCMA is free, going to the CCMA if it isn't truly that they believe that their matter was unfair and that they are seeking to have that be rectified. That's what that platform is to assist people who truly believe that they were treated in an unfair manner and are seeking some kind of way to rectify that. Now I'm at the final part that I would like to share what my preference is as a chairperson to concluding the entire disciplinary hearing. But before that, I just want to thank you for spending your time with me. I hope that the information in this video has been valuable to you, and again, I would really appreciate it if you can support me to continue to bring you more content and make use of the resources I've linked down below, and watch my other videos in the hopes that if they are of value to you, I would really appreciate that. But again, thank you for being with me today. So the final thing that I just want to say is that once I've chaired a hearing, I do not as a default and not as a practice write a report after every single hearing. I have never written a report after every single hearing. At the start of my career, I worked for a company where I would chair many, many hearings in a day. So if I were to write a report for every single one of those hearings, it would be an incredibly difficult time for me to get to everything. And I would more be spending time on something that's not contributing that much value to what I'm doing. Rather, I could spend that time on something that's a little bit more important, like honing my skills as a chairperson. Now, that being said, I do sometimes write outcome reports. I write outcome reports when I am asked to, and I write outcome reports when I think it is best to do so because there are other parties involved in this that the employer needs to give information through to. In those cases, I also write them, and I try to be tactful about respecting all of the individuals to the hearing, but also very factual in the way that I present that information. So the example with that is I've often chaired hearings for schools and daycares where parents are involved. Parents would like to know if there was an incident involving their children. So I will write a report knowing that this report is to be presented to the parents of a child that was involved. Or this is a similar case if there is customers involved or there is media involved. It's some kind of case that got a lot of attention, and I know that there are people who want answers. Then I write a report specifically for the purpose that the other party who somehow is connected to this can get this information. But again, not as a default. Also, the form that I use, those are my notes. I do not take minutes in a hearing because I'm present with the hearing. If somebody wants to take minutes or record it, that's their choice to do. I don't take minutes and I don't record the hearings. I simply take notes for myself. And that brings me to the end of today's video. I know that it was a lot, but I wanted to cover a hearing in totality, and then I will make more videos about specific elements that I think is valuable to expand on. Please let me know in the comments down below which of the elements of the disciplinary hearing process or the employment relationship as a whole you would like me to expand on, and I will prioritize making those videos. Again, I really appreciate you spending your time here with me today, and I'll see you in the next video.